Hello, ladies and gentlemen, and welcome to Chase's School of Negligence. So, in the elements of negligence, there are four. You need duty, breach of duty, causation, and damages. The first element of negligence is duty. The outcomes of some negligence cases depend on whether the defendant owed a duty to the plaintiff. Such a duty arises when the law recognizes a relationship between the defendant and the plaintiff, and due to this relationship, the defendant is obligated to act in a certain manner toward the plaintiff. A judge, rather than a jury, ordinarily determines whether a defendant owed a duty or care to a plaintiff, where a reasonable person would find that the duty exists under a particular set of circumstances. The court will generally find that such a duty exists. The second element of negligence is breach of duty. A defendant is liable for negligence when the defendant breaches the duty that a defendant owes the plaintiff. A defendant breaches a duty by failing to exercise reasonable care in fulfilling the duty. Unlike the question of whether a duty exists, the issue of whether a defendant breached a duty of care is decided by a jury as a question of fact. The third element of negligence is causation. Under the traditional rules of negligent cases, a plaintiff must prove that the defendant's actions actually caused the plaintiff's injury. This is often referred to as but-for causation. In other words, but for the defendant's actions, the plaintiff's injury would not have occurred. The fourth element in negligence cases is damages. A plaintiff in a negligence case must prove a legally recognized harm, usually in the form of physical injury to a person or to property. It is not enough that the defendant failed to exercise reasonable care. The failure to exercise reasonable care must result in actual damages to a person to whom the defendant owed a duty of care. Defenses to a negligence case. One of the most commonly used defenses to a negligence claim is to show contributory negligence on the part of the plaintiff. When a plaintiff assumes the risk involved in an obviously dangerous activity but proceeds to engage in the activity anyways, he or she may not be able to recover damages for the injury.